ഏ இப்பதான் போறேன். ஹலோ.
இவங்க ஆக்சுவலாக கம்ப்யூட்டர் சயின்ஸ் எட்டோடைய வெல்கம் அட்ரஸ் கொடுத்தாங்க.
Hello, sir. Ram Jawahar, sir.
Yeah, hello, ma'am.
Hello, sir. So we'll start it, and I'll after 15 minutes you'll be having you have to go with the session, sir. Okay,
Yeah,
sir.
sure. No worry, no worry.
Okay, sir. Thank you, sir. நம்ம இது போட்டு YouTube video. YouTube இருக்கா?
करना अंदर
உங்களுக்கு வாட்ஸ்அப் இது பண்ணுவா இதுல? தோர்க்கடி மீனா வாட்ஸ்அப் பண்ணிக்கோ. பண்ணிட்டா வாட்ஸ்அப் பண்ணிருக்கியா?
இருக்கு மெயில்ல இருக்கு.
மெயில்ல இருக்கா? சரி. நம்ம வீட்ல இருந்தானா
ராம் ஜவஹர் சார்
அலைய வேண்டிய வேலை கிடையாது. நெட் ஏதாவது ப்ராப்ளம் ஆனா பிரச்சனை ஆகும். இல்லைன்னா அங்கேயே உட்காந்து சார் வந்துட்டாரு சொல்லு.
டவுன்லோட் பண்ணிக்கிறேன் மேம். தமிழ் தகவல்
ராம் ஜவஹர் சார் குட் மார்னிங் சார்.
டவுன்லோட் பண்ணிக்கிறீங்க அப்போ?
Good morning.
Oh, good morning sir. How are you sir?
Fine. How are you, sir?
I'm very fine. We recently met in another program also at the CIT Chennai Institute of Technology.
Okay.
காலேஜ் வீடியோ எப்போ மேம் போடணும்?
இப்பயே போட்டுரு. காலேஜ் வீடியோ யூடியூப்ல பாரு. போயிட்டு இருக்கட்டும்.
ஸ்கிரீன் ஷேர் பண்ணா எல்லாமே தான் சார் ஷேர் ஆகும்.
இல்ல ஃபர்ஸ்ட் இது ஸ்கிரீன் அந்த பிபிடி மட்டும் ஷேர் பண்ணி விட்டுரு இப்போதைக்கு.
எல்லாமே தான் ஷேர் ஆகும் நம்ம பண்றது எல்லாமே.
இல்ல மேம்
ஷேர் ஸ்கிரீன் கொடுத்தா
சரி 5 மினிட்ஸ் வரைக்கும் டவுன்லோட் பண்ணிட்டு அப்புறமா ஷேர் பண்ணுங்க. இல்லைன்னா கஷ்டமா இருக்கு.
அப்பெல்லாம் பண்ண முடியாது சார்.
இப்ப நான் இதுல ஒர்க் பண்ணவே முடியாது. ஐயோ
சிஸ்டம் ஆன் பண்ணிக்கலாம்.
இன்னொரு சிஸ்டம் பண்ணுவாங்க.
சிஸ்டம் ரெடி பண்ணிக்கலாம். அதற்கு அதுல இருந்து அப்டேட் பண்ணி. சரியா?
நாளைக்கு
மேம்
Sir? Record. Hello. Hello. Good morning, all. I request all the participants to kindly mute yourself. A very good morning to all gathered here. Every day is a new beginning. Let us start this new day with lots of learning. We welcome all the dignitaries and the participants to this AICT sponsored Atal FDP on patent law for engineers. God creates an opportunity for us to do whatever we want. Let us pray God Almighty for this new start. Let us all join for Tamil Thai வாழ்த்து.
நீ அப்படியே ஷேர் பண்ண முடியாதா?
கண்டமிதில் தெக்கனமும் அதில் சிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிலமை திறம் வியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே. It's a glad welcome we bring you this morning, filled with desires, hopes, and dreams we all share. Let us lighten the virtual lamp for beginning our day with a ray of light. Management is doing things right. Leadership is doing the right things. Now we request such a great person who is a great leader and also who is great in management, Dr. Arun sir, Head of R&D, Pratyusha Engineering College, to welcome the participants. We welcome you, sir.
Thank you, ma'am. Distinguished delegates, participants and partakers, very happy morning to all. So it is a glorious moment to extend my warm wishes on behalf of Pratyusha Engineering College. I want to convey my heartfelt gratitude to the AICT for accepting our proposal to conduct Atal FTP on patent law for engineers and researchers. On behalf of my institution, it gives us a great pleasure to grace all your presence in the interest of the program. It gives me a tremendous contentment to be presenting the welcome speech amongst the esteemed personalities, professionals of different parts of the country and country. So before we begin this FDP, I would like to express my heartfelt gratitude to all of you who are sincerely committed to this event to make it as a success. This event would have been impossible without the support of each and everyone present here. Thank you. Over to you, ma'am.
Thank you, sir. Thank you so much. The challenge of leadership is to be strong, is to be kind, is to be bold, is to be thoughtful, and being humble. We have with us such a great leader, our principal, sir, Dr. Ramesh Babu. I request our principal, sir, to deliver the inaugural address. We request you, sir.
Thank you. Good morning, one and all present in this August gathering. And today, Pratusha Engineering College is going to conduct the patent law for engineering and researchers. So it is going to be very useful for not only the researchers and those who are involved in academics and different engineering and science activities. For those people, it is going to be very useful. I'm taking this particularly this platform to invite Dr. Ram Jawahar, Assistant Controller of Patent and Patent Mechanical, Chennai Patent Office. Welcome, sir.
Thank you.
This kind of programs must be conducted at more periodic intervals so that our society will get benefited. Particularly in India, the awareness of the patent is very poor. So whereas if you go to the some foreign countries, Western countries, we can able to see that the comparing with their population, the patents get filed is the number of patents get filed is very high. So that situation should come for our country also. So this kind of programs will initiate all those things. Particularly, Pratusha Engineering College is concerned 20 years old institution, having very good academic records and keep on conducting these kind of programs for the for the betterment of the society. And this institution is concerned within 20 years of time duration, around 66,000 graduates have been get graduated in undergraduation and post graduation from this institution. Also, at present, 1,900 students are on roll, and around 350 faculty members are present here in the institution, and having a lot of industry tie-ups and closely working with the different industries. And we established a different center of excellences in the area of the latest technologies along with the Indian and foreign industries. And we feel proud to conduct these kind of programs. And I hope that all the 200 participants throughout India participating from the different states, not only from Tamil Nadu, Andhra, Kerala, Karnataka, and also from North India, different parts of the India. It's a pan India program. All are going to enjoy the program for the next 5 days. And particularly that program is going to be conducted by different uh, people involved in different patent filing processes. And so the different attorney generals, attorneys of the patent from the throughout India going to deliver the speech. This program going to be very useful for all of you. And I once again I thank Ram Jawahar sir, and then our head of R&D, Dr. Arun, and all the coordinators for arranging this program. Thank you. Thank you once again. I hand over the stage to Mr. Ram Jawahar, Patent Officer, Assistant Controller of Patents, Mechanicals at Chennai Patent Office. Thank you, sir.
Thank you, sir. Curiosity about life in all of its aspects, I think, is still the secret of great creative people. We have with us such a creative and curious personality, Dr. S. Padma Priya, coordinator of the Sattal FDP, coordinator of research, Pratusha Engineering College. We welcome you, ma'am, for introducing our chief guest.
Good morning, dear professors. Hope all are safe and healthy. I want to remember you all the words of our beloved APJ Abdul Kalam. Every pain gives a lesson, and every lesson changes a person. So all be brave and strong. Keeping this note, I welcome you all to Pratusha family and for the day one of the Atal FDP on patent law for engineers and researchers. Develop a passion for learning. If you do, you will never cease to grow. Now, we all hear the buzzword intellectual property rights, and our government has taken steps to improve IPR in nation by many initiatives like Kapila by MHRD. Most of them are aware of all the types of IPR, but we should know about the rules and laws behind IPR. Hence, we all begin with great learning on it in these 5 days. I take pleasure to introduce our speaker, Mr. Ram Jawahar, Assistant Controller of P&D Mechanical, Chennai Patent Office, of this session on Introduction to Indian Patent System and Patent Law and its Concepts. Mr.M. Ram Jawahar is Assistant Controller of Patents and Designs in the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India since 2003. He has examined and granted more than 15,000 new inventions. He is a mechanical engineer, obtained his ME Internal Combustion Engine from College of Engineering, Anna University, Guindy, Chennai, and M.Tech Polymer Science and Engineering from College of Engineering, Anna University, Guindy, Chennai. He has more than 4 years of teaching experience in the Department of Mechanical Engineering, College of Engineering, Guindy, Chennai. He obtained DL 101, General Course on Intellectual Property Rights, WIPO, Geneva, and DL 201, Copyrights and Related Rights, WIPO, Geneva, 202, Electronic Commerce and Intellectual Property, WIPO, Geneva, and 318, Advanced Courses in Patent Information Search, WIPO, Geneva. He also obtained PG Diploma in IPR. He has been to Japan for 3 months to study the procedures and the system practiced at Japan Patent Office. He has also obtained a certificate course in German language from the University of Madras. Welcome you, sir, for this session, and the floor is yours. Thank you, sir.
Yeah, thank you. Thank you very much for giving this wonderful opportunity. Hope you hear me. I take this opportunity to thank your principal Ramesh Babu sir. He is rightly pointed out that the patents granted, that is awareness. The point of view awareness is very less as compared to other foreign countries. Okay, that is a.
So 1 minute, sir. 1 minute, sir.
Yeah.
1 minute, sir. Participants here, mute your mic during the session. Thank you, sir.
Yeah, can I start now?
Yes, sir. Yes, sir.
Yeah. So he's rightly pointed out that in India, the awareness point of view is very, very less. So we need to raise the awareness to all the participants. That is very, very important. It doesn't mean that we don't have inventions. We have enough inventions, but the point of view is yeah. Can you able to see my slides?
Yes, sir.
Yeah. Fine. Yes. So today the topic given to me is the introduction to Indian patent system and patent laws as concepts. So he rightly pointed out 15,000 patent applications I have granted, but I would like to say you that is out of these 15,000 applications, nearly around 13,000 applicants I met are not Indian applicants. Most of the applicants I met are the foreign applicants, and only the 2,000 applicants, nearly around 1,500 to 2,000 applicants are Indian applicants. Do you know the reason why? The main reason, because the awareness point of view is very less. So in these 13,000 applications, nearly the 18% of foreign applications are getting granted. But in Indian applicants, if you see that only the 50% applications are getting granted, many people think that the publications is the greatest achievement. After that publication, that first examination report will come. You need to give a reply to the first examination report. Then the hearing, you will give a hearing. So after that hearing, the patent will be granted. Patent will be granted. This is a once the patent grant, then your number is published in the journal, then it becomes a grant certificate. Okay, that percentage is less. But this was only about the 20% applicants was Indians. But today's scenario, it is little bit slowly improved from 20% to 25%, 30%. The recent past, I mean, past 1 year, can you believe me or not? The percentage is improved to 20% to 30%. That is a great achievement. That is a great achievement. The main reason is we have know about the factors. Okay. When we talk about patents, the base for the patent is intellectual property. What I'm going to concentrate is how the patent law is evolved, from where the patent law evolved, how it is related to our economy. Okay, those things we need to understand from where it has come. So intellectual property in the sense, it's a creation of intellect in industrial, scientific, literary, and artistic field. Not only if you are inventing something, that is intellectual property in the sense industrial, scientific, literary, and artistic field. The rights to the owner, the commercial exploitation, subject to national laws and international agreements with the intellectual creativity. What is this? We are buying a land. What we will do? We are buying a land. We will go to the sub-register office and register your product. Okay. Then the land becomes your product. In the same way, if you are inventing something, in the same way, if we are inventing something, then yeah. In the same way, suppose we are inventing something that is an invisible property, you need to register in the particular patent office. Suppose you are from South Zone, you need to come to Chennai patent office. North Zone, you need to come to Delhi, and West in Mumbai, and East in Calcutta. These intellectual property rights has a broad classification like industrial property rights and copyrights related rights. What is this industrial property rights? Okay, industrial property rights, it has various subdivisions. Industrial property rights, it has various subdivisions like patents, designs, plant variety, geographical indication, and trademarks. I'm not going to deep into all these topics. I'm going to concentrate only on patents, but we must understand in the broad sense what is the difference between patents, designs, plant variety, GI, and trademarks. And one more thing, the broad classification is called copyrights and related rights. So previously this was under Ministry of HR, but today that copyrights and related rights is also attached with Ministry of Commerce and Industry. In India, if you see that only one copyright office available, that is at Delhi. But when you talk about the patent means in the 4 offices, Chennai, Mumbai, Delhi, Calcutta, the 4 divisions are there. But in copyright office, only 1 office. Trademark office, in addition to these 4 centers, Ahmedabad also having 1 trademark office. When you talk about the geographical indication, only 1 office in India, that is in Chennai. And design office available only in Calcutta. Design office available only in Calcutta. So this is a broad classification. So from the birth of this patent system, how does the patent system born? So this thing is IPR law and concepts regarding patents. There are various treaties were signed. So treaties in the sense, the first thing is PCT. This is a patent cooperation treaty. What is this PCT? That is the international patent system. For example, you want to protect your invention. In India, it's nothing harm. You come to Indian Patent Office and file a patent. But if suppose you think that your patent has got a very good value, your patent has good value. In this scenario, if you want to protect your invention to some other countries, you can go to other countries and file a patent. That is also fine. Within 12 months time filing a patent in India, then you can very well go to the other country and file a patent. But there is a system called Patent Cooperation Treaty. India is member of PCT. If you file a patent in India and with a PCT application, within a year time, we will forward your application to WIPO, World Intellectual Property. The coming slides, I will tell you about what is WIPO, what is WTO, how this patent system is related to WTO, how it is indirectly affects the economy. All these things I am going to talk in the coming slides. What is the important law and futures in 2016? What all the changes has happened? So all those things in the coming slides I'm going to talk. So before that, in PCT, 152 country means we forward your application to PCT WIPO Geneva. What the WIPO people will do, they forward your application to all the 152 countries. So then these people will contact you. In the meantime, these people will contact you. So you need to communicate with those people and get it. It's a simplifying process. Instead of going to each and every country, if you file one single patent, that will be forwarded to WIPO. Once it is forwarded to WIPO, WIPO will forward your application to all the 152 countries. And these 152 countries, some countries we may think that there is no market value. So we may not concentrate on those countries. So in this scenario, what we people do is, for example, Europe has a market, US has a market, Japan has a market, means you can choose only those countries and file a patent and proceed with your application. That is the importance of PCT, Patent Cooperation Treaty. Many people think that it is a new concept. It is not a new concept. These are all very old concept. Even in the 18th century, all these things were happened. In patent, some of the important things are happened, like in 1977, the treaty called the Budapest Treaty. In Budapest Treaty, you need to deposit the microorganisms. For example, this is related to the biotechnology and people. What is this microorganisms? In the sense, for example, people know about the case of Anando Chakrabarti. So Anando Chakrabarti, he has invented some microorganisms. If suppose the oil spills into the sea, if suppose oil spills into the sea, then what happens? The sea will get contaminated. So he invented some microorganisms. These microorganisms will capture or will eat all those spills of oil. So this is indirectly helps to protect our nature. So you need to deposit these microorganisms, right? Then Washington Treaty. Washington Treaty, it is mainly for integrated circuits, layouts and design. But this treaty is, of course, it is not in force. So design, the Paris Convention, it talks about more about that design related rights. In 2000, the separate patent law treaty also introduced. Separate patent law treaty also introduced. So the designs, if you take about designs, so design is also one of the important factor. Don't think that a design is a new concept. A design is one of the important concept. That is something like the Hague Conference. The Hague Conference, the industrial design system. In patent, in the sense, all the technical features were involved. But in a design system, there is not at all any technical features, only the aesthetic appearance. In the view, in the raw eye, what you are seeing, only the aesthetic appearance comes into picture. For design related rights, the amount we are spending, amount we are spending to get the design is only 50%, but the market value is more. But the market value is more. That is the reason why the famous story the people used to say the Pepsi and Coca-Cola. The Pepsi and Coca-Cola were the competitors. Once what happened, the Pepsi sales was started overtaking the Coca-Cola sales. Then the Coke people, the board of directors met. How to change this situation? Why the Pepsi completely overtakes Coke? In this scenario, the people met frequently and whether to change the formula or not. If you change the formula, then that will become a patent rights. Whether to need the formula, change the formula or not. Then finally, people decided not to change the formula, just change the design of the bottle. That is the reason why the previously Coke bottle in the straight shape. Then after a recent Coke bottles, if suppose you see that is in the curved shape, that is in the curved shape, they introduced the bottle in this particular shape. So after 2 years time, the people noticed that Coke also started overtaking Pepsi. There is no change in formula. The only change people did is the design of the bottle. So more particularly in the colleges and in college canteens. So some of the people, those who are interested, they do some survey regarding in this concept. They ask the college students, previously you people drink only Pepsi, now you started drinking Coke. What is the reason? You like the taste of them? People said the holding Coke bottle, it gives some pleasure. Many people said that holding a Coke bottle is something like holding my girlfriend, like that they say. So this is a very small improvement. The percentage we spent is very, very little, but the sale value is high. That is the importance of design related rights. That is the importance of design related rights. For example, the features like, what can I say, in Hyundai car, the i20, other car is Accent car. So both the cars are having a same features. If you see that their combustion ratio is 1200 cc, there is same emission system, same transmission system, nothing more. The same emission and same transmission. But of course, one sales is more than other because of its simple design. Because of its, that is the importance of design system. Even in 1883, the Paris Convention talks about design related rights to protect industrial design. So in the same way, the copyrights, there are various treaties were signed in copyrights related rights. So in copyrights related rights, the first thing is a Berne Convention. What is actually this Berne Convention? So Berne Convention, literary and artistic field. Literary and artistic field. Literary and artistic field in the sense, if suppose you are having some artistic skill that you can protect, and if suppose you are writing some book that you can protect under copyright related rights. And Rome Convention, it is a little bit advanced one, something like a performance and phonograms of producers and broadcasting related rights. Nowadays, the more problems are happen in broadcasting rights. Who's to telecast the Olympic ceremony, whether Star Sports or Sony? Why? How the rights has happened? So one, Sony has get the permission. Those people not allowed to telecast, or TV people not allowed to telecast. These disputes were solved in the, the rules were framed in the Rome Convention. The performance rights, if suppose you are performing, others cannot copy your performance. This is very much covered in Rome Convention. Then WIPO. WIPO is Performance and Phonographs Treaty, and Marrakech Treaty is blind and visually impaired. So for blind people, the style of the reading style, that also you can protect. That thing is protected under Marrakech Treaty. Okay. Then Beijing Treaty in 2020 This is about that audio visual performance. In 2020, recently in Beijing Treaty, the audio visual performance introduced. 2020 audio visual performance introduced. So once this is about that copyright and related rights. When we talk about the copyrights and related rights, so what happened to SPB and Ilayaraja? That question the people always used to ask. So this is the very complicated things. In today's world, the producer is giving money to music director as well as singer and for director. So what producer claims is, I already paid money to all the people. So all property belongs to me. So today's scenario, the music directors like A.R. Rahman, what they are doing is, even though you are paying money to the music director, all the rights are reserved with music rights reserved with music director. Like that, the separate agreement is there. Unless otherwise, in Ilayaraja period, there is no such agreement was there. Okay, if no such agreement there, then the ratio is something different. Nobody has made such agreement, means 5:3:2. Okay, these type of things were always there. Okay. So trademark and GI. When you talk about trademark and GI, there are many agreements were signed. One is called Madrid Protocol. Madrid Protocol. What is trademark? For example, the emblem. Any mark. So yeah, the college has got some mark, means that is very, very important. So recently the people were confused. In the same name, there are many colleges were there. For example, Loyola College, Loyola Institute. There is many things. When they attend that counseling, they never know that which is the original one. The many people, they wrongly choose the other one. When they go to the main college, then they says that this code is different. That why these things are happening? Because the people are not registering their trademarks. Once they register their trademarks, others cannot use the particular name or part of the particular name or something which gives confusion to the people, that will not approved by trademark office. That is in Madrid Protocol. It's not a new concept. In 1891, the international trademark system, all these rules were very well established. Okay. So in 2009, there is a small modification is happened. That is in Singapore Treaty on Law in 2009. What is the Singapore Treaty on Law? This talks about extension of time. So many people, they forget to do extension. In trademark, initially for 10 years time they give, then every 5 years you need to renew. People forget to extend also. The extension of time concept, it is introduced in Singapore Treaty on Law. And recently one treaty has signed, that is in Nairobi Treaty, the protection of Olympic symbol. So Olympic symbol means immediately you know that that is a 5 rings. 5 rings, the one ring in blue color, other one blue, I think blue, yellow, green, black and red. So blue indicates that is European nations. Green indicates Australia, Australian continent. Red indicates American continent. Black indicates African continents. Yellow indicates, of course, it is Asian continent. So these 5 continents are participating. So in these same interlaced rings, some people use this for their commercial advertisement. So this should be completely stopped. The protection of Olympic symbol, that treaty was signed in Nairobi. That is called Nairobi Treaty. Okay. So the Lisbon Treaty, what is this Lisbon Treaty? It is something talks about origin, appellation of origin. Origin in this sense, it is geographical indication. What does this geographical indication says? Geographical indications in the sense origin, like Kanchipuram sarees or Tirupati Laddu, Madurai Malli, Pattamada Pai, and Dindikkal locks. So all these things comes under these trademark related rights. all these things were comes under these trademark related rights. Okay, I mean the trademark and GI. Okay, so classifications, the classification is one of the important factor. What is this classification says? For example, many countries, they don't know, I think all the world countries, they are not good in English. For example, when we are granting application, the countries, the European countries, American countries, that is English documents were there English. So all the inventions were in English. But some of the countries like Korea, Japan, and China, only the abstract we can locate in English, but other things may be in other languages. So very difficult to understand these languages. So in this scenario, this classification helps. So there is a universal classification. For example, A01, B0100 means this indicates the IC engine related inventions in the field of Viper, in the field of timing. So all these things, by giving this particular number, so we can say that what invention it is. So the classification plays the important role, that is called Vienna Agreement. So this Vienna Agreement initially gives the foundation for this classification. Then Strasbourg Agreement establishes international patent classification. International patent classification. So all these things were detailed report were included in Strasbourg Agreement. Then next to this Strasbourg Agreement, the NICE Agreement is international classification of goods and services and registration of marks. So this agreement, the Vienna Agreement, this Strasbourg Agreement, which talks about the patent related inventions. In the same way, if suppose the trademark, the people wants to classify the things, means that also some classes are there. That is covered in NICE Agreement, the international classification of goods and services for registration of trademarks. In the same way, if suppose you are filing a design application, nowadays not only in patent application, many design applications received to our office from many colleges. So once the design application receives, what we do is we forward your application to Calcutta. The Calcutta, we have a design office. So Calcutta people do the examination within 6 months time, that will be granted. Or if suppose some objection, that will be notified to you. Okay, that agreement is called Locarno Agreement. In Locarno Agreement, the classification for design related things, classification for design related things were completely covered. Even in the application also, the people asked you to fill the under what classification, under what class it covered, give the class and the sections. That you need to refer the Locarno classification. Just type the Locarno classification in Google, all the design classification symbols will come. So you can choose your product under this class, then you can very well apply. So these are all the main agreements. These are all the backbone of the intellectual property rights. It is not just like that evolved. It is evolved stage by stage. Okay, it is evolved stage by stage. So initially the patent system has evolved. So first thing is we must know about what is GOT and WTO. I'm not going deep into the economic related things, but we must understand what is the basics. What is the basics of GOT agreement and WTO agreement? GOT in the sense General Agreement on Tariff and Trade. General Agreement on Tariff and Trade, and started in the year 1948. Started in the year 1948. So main thing for the introduction of GOT is the substantial reduction of tariff. So substantial reduction of tariff, the system called GOT introduced. Okay, system called GOT introduced. So substantial reduction of tariff. No, but the problem with GATT is no dispute regulation. There is no dispute regulation. It is not institutionalized. There is no compulsion to follow his norms. So these are all the drawbacks in GATT. These are all the drawbacks in GATT. The main difference between the GATT and WTO, the GATT is an agreement, is ad hoc or provisional. Only the trade and goods, no dispute settlement. So in GATT, every country, the local laws may be different. But what WTO says is there is a uniform practice. When you talk about WTO, it is a institutionalized. There is a difference between the agreement and institution. So this is institutionalized. This is not the ad hoc or provisional. This is a permanent body. WTO is a permanent body. So not only trade and goods, the thing like services, is also included in WTO. In WTO, if suppose the dispute happens, the separate body, the separate committee, the called dispute settlement committee, if whatever the dispute happens between nations, this committee will resolve your disputes. The separate dispute settlement board is there. But in WTO, in GATT, there is local laws are different. In WTO, that is uniform laws all over the world. Uniform, there should not be any discrimination. Everybody should be treated equal. That is the WTO's main stand. Equal treatment for all countries. That is not like the most favored nations. The same treatment for all nations. Same treatment for all nations. That talks about WTO. So in WTO, some more things are there. So when the WTO, the concept was introduced, even in the parliament, there were so many disputes. Like India should not become a member of WTO, like that some disputes were happened. But it's a duty of government of India to give the justification why India becomes the member of WTO. Why India becomes the member of WTO. So main thing is the 93% of global business. The 93% of global business is under the WTO. If you are not becoming a member of WTO, then what will happen? You will be isolated. Your country will be isolated. Then WTO says that 3% of compulsory import. So WTO says that 3% of compulsory import, but that factor will not affect because now the percentage of import we are doing is much more than. These are the criticisms, but it's a duty of government of India to give the justifications why India became the member of WTO. Then some people say that medicinal prices will go up high, but medicinal prices will never go up high. It is depends on supply and demand. It depends on supply and demand. And under Muraki's agreement, WTO is formed. So free and fair trade. For example, how the patent is related to WTO? If suppose, if you do some inventions, automatically you will get a royalty. If suppose you do some inventions, automatically you will get a royalty. So your trade will improve. Once your trade will improve, automatically your economy will improve. Once the economy improve, your GDP will improve. Okay. So in this scenario, WTO plays the important role, and your invention plays important role to improve the country's GDP. Improve the country's GDP. to remove trade barrier is very important. So trade barrier, what the WTO other countries are saying is trade barrier. Trade barrier in the sense there is a two important thing. One is called tariff barrier. Other one is called non-tariff barrier. What is this tariff barrier? What is this non-tariff barrier? So tariff barrier in the sense, the tariff barrier in the sense, what can I say, the export duty and import duty. For example, the Harley Davidson bike which comes to India, that is 100%. Recently the Vijay also faces this problem, the 100% of import duty. If suppose the cost is 2 lakhs, means another 2 lakh to government import duty. This is a fixed price as a 4 lakh rupees. Okay, that is import duty. Why this type of thing is there? Because otherwise what will happen? Our Indian manufacturers, for example, Rolls-Royce car, we are giving the 100% import. Otherwise what happen? Our industries, Indian industries will not move. Indian industries may face the problem. Indian industries may face the problem. And second important thing is export duty. The export duty in the sense in India, if so, even in onion also, the 100% export duty. What do you mean by this export duty? If we are not imposing this 100% export duty, so all the onions will be exported to other countries. So there is a scarcity will come. So in tariff barrier, one is import duty, other one is export duty, and non-tariff barrier, get license to India. Whatever the product which comes to India need to get license from India. For example, the Tesla car comes to India means what will happen? The same like Tesla battery car, even Tata also having a beautiful battery car. So these people may face the problem. In this scenario, they get license from India to import this particular car. This is a non-tariff barrier. Then subsidy. If the American government is giving subsidy to Tesla car, for example, if it is 50 lakhs, you are giving 50% subsidy, means then it is 25 lakhs only. So our people will not compete. So India will give some duty, because many things what we people are doing to boost our inventors, Okay. The next thing is the safety regulations. If you talk about the safety regulations, recently, if you believe me or not, India is exported mangoes to other countries. The people rejected all the mangoes. The reason behind is some bug inside that mango seed. That is the reason why they rejected entire export. This is a safety regulation. So main thing is the tariff barrier, non-tariff barrier, production subsidy, then safety regulation. And WTO and agriculture, it's one of the important things. So our country, India is a country which gives more subsidy, because domestic support in agriculture. We have a ration shop. In ration shop, we are giving all the subsidies to the people. So what other country says is stop this one, because amber box subsidy, blue box subsidy, and green box subsidy. In amber box subsidy, the India is giving subsidy to the poor farmers, because the country is poor country. We are giving the many things in free of cost through ration. So what other countries to stop this amber box subsidy? Once you stop this amber box subsidy, then immediately other countries can come inside directly into India. Directly they can compete with our farmers. So their demand is stop amber box subsidy. And one more thing they say is the blue box subsidy, you fix up. If suppose the farmer is having this many percentage of land can eligible to get the subsidy. If a land percentage is more, or the rich farmers not eligible to get the subsidy. Okay, that is amber box subsidy. Then blue box subsidy, amber box subsidy. Then India's demand is even in US they are giving green box subsidy, in the sense for doing that research, agriculture related research, the government is giving more subsidy. So stop all the green box subsidy. Once you stop the green box subsidy, then we are ready to waive the amber box subsidy. That is the India's demand. So all these demand, there is in WTO, many conferences have happened, like in the many such conferences happened, and some of the important conference in WTO is Doha Development Round, Bali package, and Buenos Aires package. So in Doha agriculture market, okay, those countries demands agriculture market in India. What India says is, you stop all the green box subsidy, then you are eligible to come to India. Then access to the patented medicines. So today it is a corona period. So there is access for the patented medicines. If suppose they get a patent, means it is very difficult to India to procure all the patented medicines. So difficult for the people to survive. So in this scenario, what is India's stand is the compulsory license. What is compulsory license? Even though you get a patent, India has the right to get the products through compulsory license. In so far in India, only one product, government of India has imposed the compulsory license. This is one drug called the cancer drug. Okay, one drug called cancer drug. That cost was 2,84,000 rupees. The 200 tablets you record to take in 2 months' time. But the same thing, what the Indian government, the NATCO says is, I can produce these particular drugs in 8,800 rupees. In 8,800 rupees, but that cost is nearly around 2,84,000 rupees. This is just 8,000 rupees. Then the compulsory license granted to NATCO, because the poor people cannot afford to buy those medicines the higher cost. So they approach the IPAB, Intellectual Property Appellate Board. In today's scenario, there is no appellate board. The appellate board is also removed. So they, 5 years back, they approached the appellate board. So what the appellate board says is, what government of India said is right only, but the decision is excellent decision. They need to pay a royalty because they are the producers. They spent so much of money in R&D. They spent so much of money in R&D. So they need to pay, NATCO need to pay 6% of royalty to the company, the owners, to the Switzerland owner companies. Okay. This what the compulsory license mean. So this this topic is a very hot topic today's scenario, access to the patented medicines because of the corona related disease, and special and differential treatment, and special and differential treatment and safeguard mechanism. Special differential treatment and safeguard mechanism. These are all the some of the important classes in WTO. Okay. Special and differential treatment in the sense, for example, as per in the Kyoto Protocol, who are all the nations in developed nations, who are all developing and who are all underdeveloped nations. But as per this WTO, it is optional. So India and China, these people opted for the least developed nations. And safeguard in the sense, for example, the New Zealand dairy products people, they come to India, means Indian milk vendors, they may face problems. So people are imposing some duty for the special safeguard mechanism, special safeguard mechanism. In Bali package is nothing important. Customs procedure, 9 to 14 days. If whatever the products comes from other countries, it takes 9 to 14 days to come inside India. So as per Bali package, make the customs procedure simple. Make the customs procedure simple. That's what they said, and they always target on remove the public stock holding. Remove the public stock holding. What India stand is, India is a country, a poor country, so we cannot remove the public stock holding. Then they have given 4 years time. Within 4 years time limit, you need to remove the public stock holding. But India objected that once the poverty is eradicated, then we are ready to remove the public stock holding. And these 3 conferences are very important. And one more thing is the Buenos Aires conference. So e-commerce, they have a class. So every country has a quota to export, but the country which has, India imported some of the products. What they said is, the country which has a woman inequality not ready to, not allowed to export. Like that, those classes are there. India is also objected that particular class. Okay. This is something like that. TRIPS is there, then TRIMS is there. Okay, what is the advantages? What is the advantages of patents in the sense it avoids duplication of research? It avoids duplication of research. What is duplication? Duplication in the sense identical products. Duplication in the sense identical products. So previously, before joining this patent office, I was working in College of Engineering, Guindy. So that time I visited some of the engineering colleges as external examiner. One student started explaining his invention. He started explaining his invention. So immediately I appreciate the student and we given a very good mark. Then when we go to other college, that student also started explaining the same invention. Then immediately ask a question, where you are copied. He has not copied anywhere. But thing is, he has not done any literature survey. He has not done any literature survey. Okay, that is very, very important. That is a reason why if you see the BE project work in today's scenario, nearly around 30 to 40% of projects works are repetition. We need to avoid all those things. So some people they approach the BE project sellers are there. These people are selling the project, or don't approach those people. There is no use. Okay, if you approach those people and buying, means there is no scope for Indian economy will improve. So you do whatever the invention. If it is very small invention also, you do it by yourself. That is the avoids duplication of research, avoids duplication of, and keeps the abreast with latest development in the different fields of technology. Latest developments in the different fields of technology, and helps industry to improve the latest developments in different fields of technology. Okay, before doing your project work, what you need to do is whether this invention is available or not. That you check. Without doing that literature survey, if you are there is no use. There is no use. Okay, that is very, very important. So in this scenario, I forgot to say some of the services, like in intellectual property, the one service is called GOTS. GOTS means the services sector. It is mainly for services sector. That is 4 different services. One is called cross-border services, mode 1. Mode 2 is called consumption abroad. Mode 3 is called commercial presence. And mode 4 is called presence of natural person. What is this mode 1? Cross-border services. The cross-border services in the sense, for example, it is something like a perfect example for a BPO. The customers were US customers, then call centers in India. People work from the call centers. This service is called cross-border service. It's mode 1. It is covered under GOTS. And consumption in the sense of medical tourism. The customers were moving for getting treatment in US, for getting treatment in London. The customers were moving. Okay, that is called mode 2 of services. And mode 3 is called the commercial presence or service provider moves. The service provider moves from one place to other place. Service provider moves from one place to other place. For example, KFC or McDonald's, the service directly moves from one country to other country. Okay, mode 4, the presence of natural person. The presence of natural person. It is completely opposite to mode 2. This I am not going deep into GOTS, but I need to say something about what is this GOTS, the services sector. What is this services sector? Okay. Next to this is the TRIPS. TRIPS is if India framed the Patent Act. How India framed the Patent Act? So just like that, we cannot frame the Patent Act. The creation of mind, trade related intellectual property rights. There is a framework is there. Part 1 of the TRIPS says that how to frame a copyright law, how to frame a patent law, how to frame the all intellectual property laws, all those things. It is explained in part 1 and part 2 of the TRIPS chapter. And part 3 of the TRIPS chapter is most important chapter, enforcement. Even though you are doing, you are getting a patent, but there is no enforcement in the sense there is no use. Enforcement in the sense there is no use. Okay, the enforcement standards were discussed in TRIPS. So enforcement standards were discussed in TRIPS. In the same, like based on the TRIPS law only, Indian Patent Act is taken from TRIPS only. So 90% of the portions are taken from TRIPS. So some of the few laws like section 3D, no country has section 3D. What is section 3D says? Non-patentable inventions. Section 3D record efficacy, the percentage of efficacy. How much percentage? What is the improvement percentage? If suppose at the end of the year, the patent lifetime is only about 20 years. At the end of the 20th year, what the people will do? They do some small modifications and make one invention. So those things may be objected under section 3D. Okay, these are all the special laws. So section 2, which is talks about what is novelty and inventive steps, but section 3 and 4 talks about non-patentable inventions. So in the same way, TRIMS means trade-related investment measures. Trade-related investment, it is something that in the newspaper you might be seeing what the term called bullionism. What is a bullionism term? It is a gold standards. So as per TRIMS, the term called FDI and MIGA, Multilateral Investment Guarantee Agency. This, what is the use of this MIGA means? For example, if foreign companies or any companies which start the company in India, but some natural calamity, something else is happened, unexpected things. Something like, for example, the Sterlite in Tuticorin suddenly closed means, so immediately there is huge loss for the company owners. If suppose they were the members of MIGA, so immediately the entire compensation will be done. It is like insurance, those people will take care of this. So in this scenario, the TRIMS is very, very important. The MIGA, multilateral investment guarantee agency to protect the investments. For example, the Sterlite related cases, and WIPO, World Intellectual Property Organization, the head office at Geneva. In WIPO, whatever the calamity happens or whatever the disputes happen between the nations, those people are ready to solve the problems. World's Intellectual Property Organization. World's Intellectual Property Organization, when you forward your application, they will forward that particular application to all the member nations. That is the importance about WIPO. So next thing is the government of India to build our economy. The recently the framed structure is called the BRICS. The people know about what is BRICS. So BRICS is nothing but the developing countries like Brazil, Russia, India, China, and South Africa joined in the year 2010. So these countries, they form a group called BRICS. So there is no need to go to World Bank. These people have a fund-related program. These people have a fund-related program. So if any country wants fund, directly we can get fund from the bank is called New Development Bank. New Development Bank, nearly around 100 billion American dollars there in this bank. So China invested in 41 billion. So not to depend on IMFs. No need to depend on IMF. Okay. So during emergency, we get fund from NDB, New Development Bank. So why these steps were government of India taken is to build the bright economy, or base should be strong. So all these things are the base for the intellectual property rights. Once you do an invention, you think that it is, what is the difference between the paper publication and getting a patent? Many people are concentrating on publishing paper in the journal. In journal publication, there is no legal. You are not worrying about money making. If you are doing some work, suppose you are doing some work, there is no money comes in, there is no interest. People will lose their interest. What is the reputation? Everybody is appreciating, but you are not getting money. People will get bored. So patent means it's a techno-legal document. Patent is a techno-legal document based on your claim. If suppose you are getting a royalty, definitely that is a biggest and bright factor. So time period is very, very important. If suppose you invent something, don't take, immediately approach the patent office. Many people, they are interested in publishing papers. Okay, even though if you publish the papers, your own invention will become your enemy. In this scenario, 29 of Indian Patent Act, if suppose the same inventor published the article before filing a patent, in 1 year time, you come to patent office and file a patent. Then we will not cite your own invention. If it is more than a year, then definitely your own invention will become your enemy. Your own invention will become your enemy. Okay, helps industry to improve existing technology and produce a cheaper and better product. Serves as an indicator of achievements in R&D. R&D is every country, every company which has a product, means that 30% they need to invest in R&D. It should be a proper R&D. The some of the R&D I met are people having R&D, but nothing inside there. I asked the people, why you are having R&D? You are not producing anything. There is no proper facility. What the people said is, sir, if you are having an R&D, we will get some tax benefit. This mindset, this scenario must be changed. Once you change this mindset, so definitely our economy will improve. The patent system will also improve. So main object of this patent system is to encourage the inventors work the patented inventions on commercial scale. Patented inventions on commercial scale. Just getting a patent, make a photo frame and keeping it in your home. That is not important. Technology transfer, the term called technology transfer. You get a technology, obtain patent, and after getting a technology and after getting a patent, make money out of your invention. That is very, very important. The patents not granted for mere importation of patented articles into India. Okay. So what is patentable? Patentable means I'm not going because the people will take these things in the separate class. So I'm not going deep into all these things. So what I want to concentrate is what is the special features in Indian Patent Act. If I ask you the question, the time period is very, very important. Once you invent something, immediately you please approach the patent office and file a patent. If I ask you the question, who is the real inventor of telephone, means immediately everybody will say that, sir, it's Alexander Graham Bell. Do you know the story of Alexander Graham Bell? So Alexander Graham Bell, he is the inventor of telephone, but he approached American Patent Office in the morning. Eliza Gray, he is a person, he also did the same invention. Because of his the traffic jam or something like that, he approached the patent office in the afternoon. Alexander Graham Bell reached the patent office in the morning. Eliza Gray reached the patent office in the afternoon, but nobody knows about who is Eliza Gray. He never copied. This man lives in some other area, this man lives in some other area, but unfortunately nobody knows about who is Eliza Gray. The time period is very, very important. Once the idea strikes into your mind, immediately approach the patent office. Don't delay. Once you delay, that's all. Someone comes in between. Even in the telephonic controversy, so one more person comes in between. His name is Antonio Macusi. So he also approached the patent office. The 16 years before Bell, he demonstrated in front of the Italian press. Okay, sent his invention to Western Union Telegraph Company. Okay, there is so many things were happened in the telephone controversy. So he filed the case. Finally, the Macusi sued Bell in the court. But only about Alexander Graham Bell, the main reason is he approached the American Patent Office first. Even though you do your invention or not, that is not important. When you approach the patent office, if you delay the period, it has a commercial value. Then, for example, the many people, he approached me, the people working in I mean, they were studying in a college. The project of the 4 people have done the project work, they filed the patents. That's a very good patent. I appreciated these people. So once the patent granted, then technology transfer happened, then commercialized their patent. They got a royalty. Then finally what happened, once the royalty comes into picture, the second person comes, sir, this is actually the real owner is me. I have a right. And one more group came. These people all already stole my invention. So like that, once the money comes into picture, what happened? There is no friends. There is no money involved. Then people are very good friends. Once money involved, so there is a legal documents are very, very important. You make a legal document. For making the legal, once you go to the court, definitely the jury will ask the questions, who filed the patent first? Who got the patent first? That matters. That is the importance of intellectual property rights and patents. So if I ask you the question, who is the real inventor of radio, means everybody, the people says that it is Marconi. Marconi, he is a person who received Nobel Prize for patent. I mean, for radio, for inventing radio. But I think you know about the person name. He is very famous person, Nikola Tesla. What he said is, this is my work. Marconi stolen my invention. There is a, but initially speaking, Marconi's 3 patents were rejected because these 3 patents were similar to 17 Tesla patents. But finally, what happened? Marconi got the patent for radio, inventing radio. So Tesla filed the case in the court. The proceedings, like India, the US also, the proceedings was happening so many years. In 1937, Marconi died. And in Tesla, I think Tesla died in the year 1943. So after his death of Tesla, that is 6 months after death of Tesla, there is a judgment came in favor of Tesla. Whatever the inventions, whatever the patents granted to Marconi is invalid, the inventor is Tesla. But even our textbook says that Marconi is an inventor for radio. But actually speaking,
कोर्स करतोयस आणि 7 वर्षानंतर पहिला कोर्स होतोय मध्ये हा हॉल नवीनच झाला हा वापर मग तिथे ऑडिओ सिस्टम वगैरे सगळं करून घेतलं त्या पटापट त्यांनी एसी लावून घेतली.
So actually speaking, the Tesla is the real inventor of radio. Tesla is the real inventor of radio. So many people ask me the question, sir, once I file the patent, it takes so much of time to getting a patent, that is 7, 8 years, 10 years time. Like that complaint was there. But recently the many people were recruited in recent scenario. So nearly around 200 people were recruited. Once today, if you are filing a patent within 2 years time, you may get a patent. And in 2016, one amendment has come. So amendment in the sense that is expedited patent examination. So expedited patent examination, there is a 2 queues were there. One is called other queue is separate queue. Within a year time, the patent will be granted. That is form 18A you need to file, and as per the 2016 amendment, section 24C, as per section 24C, you can apply through these the expedited examination, but you need to pay the fee more. Once you pay the fee more, so it will come in separate queue. Even though if ordinary patent also, today's scenario, in 2 years time, you will get a grant certificate. So expedited patent examination under 24C. So who are all the people can file these expedited things means immediately the provision is given to startup companies. The provision given to startup companies. Then many people ask the question why it is given to startup companies. So recently, a year back, last parliament session, they decided that even one applicant or inventor is a woman, then also they can come in expedite patent examination. That is the reason why the many people, the 4 inventors are there, means it's one inventor is a lady. So then they can also use this opportunity, expedite patent examination. In 2016, that procedure was introduced. In 2016, that procedure was introduced. Okay. So in the same scenario, there is so many case studies were there regarding the lasers. In lasers, I think you know about this story. The person called Gold. He was a student. This person actually might have the credited for a laser. What this person, he done a wonderful work regarding laser. Then after these things, what happened? He discussed with his teacher, discussed with his guide. This person discussed the concept with his guide. He is from the Columbian University. Discussed the idea with his physics professor, Charles H. Towns. So this person has given a beautiful idea about. He knows about all the discussions that took place, and finally, without the knowledge of the student, his student Gold, this professor filed the patent. He patented it, and he got the patent. At one point of time, the student came to know that it is my idea. I discussed with my professor. My professor filed the patent. Then he filed a case in the court. So that is a 30 years of patent war happened in the year 1988. In the year 1988, the student won the battle and received the patent, and millions of royalty received. Not only a rupee, it's a million of royalty received for the student. So keep it secret. Keep it secret. Don't freely discuss with the beautiful ideas. If you have a beautiful idea, you never know that your idea is beautiful idea. You may think that it is a very ordinary idea, but that has a commercial value. If you are freely discussed with some companies, if you are going to some companies, you freely, that company people may file a patent, means so you don't enjoy the benefit. The same thing happened, I think, in Viper technology. If you are driving a car, you might be noticed. Once you, during the rainy days, the Viper cleans the windshield. Once you, even the old ambassador cars, what happens? Once you switch off the Viper, what happens? It stops there itself. It stops there. But today's scenario, it is not that. Have you noticed or not? I don't know. Once you switch off the Viper, after that, the 2 rotations, then it comes back to rest. That is a beautiful invention. Actually, that one is not a big inventor. I mean, the R&D groups have found it. There is a mechanic in that particular car company. He invented this technology. He discussed this technology. He discussed this technology with the company. So after that, what happened? The company, they filed the patent. The company, they filed the patent. Okay, these people got so much of royalty. Now the many cars are having this royalty, I mean this technology only, but they have not given any honorarium to the particular person or any support to the real inventor. He as the management, what the management said, before joining the company, you have signed one agreement. Whatever the invention made out of our properties or our utilities, so the invention belongs to us. Like that, there is a one agreement. Without his knowledge, he signed, but he didn't get any royalty. The same thing happened in Japan. In Japan, I think you know about this story, the Nakamura. Nakamura is a person, he is working in a company called Nichiya. Working in a company called Nichiya, he is a real inventor of blue LED. He is a real inventor of blue LED. Then he approached the company and, sir, I am a real inventor. Then company got so much of royalty because of his invention. And finally, the company given 20,000 yen to the actually original inventor. The original inventor is Nakamura. He received only the 20,000 yen. The 20,000 yen is nothing. It is something around the 10,000 rupees. So his invention is more valuable one, but the company given very less amount. So he approached the management. You have given only the 10,000 yen. It is very, very less. So the management said, it's not possible to give more than 20,000 yen. Immediately you go to the court. But judgment is very much different. The people ask the company, the Nichiya company, to give more royalty that Nakamura can't imagine. So he received such amount. He resigned the job from the company, Nichiya company. Then he now today's scenario, he settled in US. He settled in US and he received in physics in 2015. He received a Nobel Prize, something like that. So the value of the inventor doesn't know. Okay, you may think that it is a very, very ordinary invention, but the commercial value is more. Okay, that is the importance of inventions. So inventions in the sense the section 2 which talks about three things. One is called novelty, inventive step, and industrial applicability. This is a main classification. What is in section 2 says that novelty. Novelty in the sense your invention should be new. I'm not going deep into these things. Just give a small hint about what is this novelty. You are filing a patent, but as such, the same invention is available in some other document. I am citing this same document. Then it will be refused under novelty. You may ask me the question, sir, American got patent for neem. Yes, of course, they got a patent for neem. So after that, what our people, the Indian Patent Office, the experts, they approached the American Patent Office. They shown different documents. As such, same document. The neem cures, these are all the diseases. The new neem cures all these diseases. Then actually what happened? After that, they accepted our demand. Immediately, the patent revoked. Okay, immediately, patent revoked. In the same way, the neem and turmeric also. Americans got patent for turmeric. As such, same document we people are having. So we are shown most of the Sanskrit literature and what Agathya's, that stone inscriptions, all those things we have shown. And finally, the expert has shown, finally that also revoked. Actually speaking, for turmeric, who are all the real inventors is not Americans. The Indians who settled in America, they filed the patent. Okay, government of India objected and finally the patent revoked. In the same way, the basmati rice also. Basmati rice also 20 claims they got a patent and government of India has objected. It is our property. And finally, out of these 20 claims, 15 claims were removed. Only 5 claims were allowed. So that also the 5 claims they have not taken, they have not removed because they says that it grows only in the Texas climate. The Texas, it reaches more than 50 degrees. In this climate also it may grow. So in this scenario, that is grand. The novelty in the sense, the same document. You should not repeat the reproduction of the same documents. So this may be objected under. There is a separate, the people will take you about novelty. There is separate session is there. Anyway, I give you a small hint about that special features, how the case studies related to this novelty. So next important category is inventive step. Inventive step means improvement from the previous one. Improvement from the previous one. What is a percentage of improvement? Whether it has a small percentage of improvement or more percentage of improvement. For example, if suppose you are filing a patent, I am showing the 3 documents to you. You have taken one portion from the first document and second portion from the second document and third portion from the, and by combining 3 documents, it is something like if a student is doing PhD work, he asks 3 ME students to do a project work and clubbing all 3 project work and making one PhD work means this one is objected under inventive step. Combining 3 documents, taken one important portion from the first US document, second Korean document, third Chinese document, combining these things. If you are applying a patent, I cite all these 3 documents. You have taken this paragraph from this invention, this paragraph from this invention. In this scenario, if it is objected, then definitely it is inventive step. The first one is novelty as such a same document and improvement from the previous one. That is inventive step of objections and industrial applicability. Whatever the inventions you do, the industrial applicability is a must. Industrial applicability is a must. If the invention has no industrial applicability, then definitely you will not get a patent. Recently I refused one patent. It is called the gravity machine. So there is one huge weight he is keeping, and in that weight he placed in that gears. Once a gear is moving, then it is connected with a motor. So finally he connected to the bulb. When you place that huge weight, the slowly goes down. For example, it takes 7 minutes to reach the ground. So 7 minutes the light will glow. Is it a good invention? Yes, it's an invention, but it is not a grantable invention. It is refused because any invention, if you are doing, it should be the continuous motion. It should not be a perpetual motion. So input is there. Output cannot be more than input, and it should be continuous. If nothing is continuous for temporary for some period, means it is not patentable invention. That's what the section 3 talks about. The section 3 talks about the 3A of it talks about that any invention if you are making that is contrary to well-established natural law, contrary to well-established laws, it is not patentable. For example, you are making some invention which is against well-established natural law, which is against the thermodynamics laws, that is not patentable. For you are making something, some perpetual motion machine, it's not patentable. Perpetual motion machines, it's not patentable. One person, he approached me with he makes some flywheel. He placed the flywheel at the top of the engine, and every compartment. For initially, for start the train using the diesel, the engine moves. After 2 hours time, he switch off the fuel supply. So before that, the windmill placed at the top starts rotating. Windmill placed at the top, which starts rotating. So from that, I can move the train. Is it possible? It seems like a good invention, but that will not work because it is against the second law of thermodynamics. What can I say? The Kelvin-Planck statement or Clausius inequality. The output energy cannot be more than input energy. If someone says that output energy is more than input energy, it's not patentable. Using that windmill, there is a small light inside the compartment or fan, you can operate, not the entire engine, because the energy is not sufficient. Energy is not sufficient, right? So in this scenario, it is not. These are the, please take care of the important steps before filing some of the important steps before filing patents. And anything the morality, against morality means that also not patentable. The special feature in Indian Patent Act, the no country has is section 3D of Indian Patent Act. There is an important case study, you might be knowing the Novartis case. Novartis is a company, they got the patent for cancer. They got a patent all over the world. Only country refused is India. All the countries granted patent. So we refuse a patent based on the section 3D. What actually the section 3D says? Section 3D is efficacy. You are making some medicine. That medicine can cure your fever. The same composition can cure some other disease. 2 patents cannot, only 1 patent. And percentage of efficacy. What is the improvement percentage? If it is a small percentage of improvement, that is not patentable. So recently the concept called the evergreen patents. The patent lifetime is only 20 years. At the end of 19th year, what the people will do? They approach the patent office. Small modification they do and file a patent means it's already disclosed. The small portion you are attached. For example, the composition has 10 mixers. You have taken only 1 mixer and adding some other mixer. Because of this mixer, the percentage of, what is the percentage of improvement? There is very narrow percentage of improvement, means it will not be granted. Okay, that is section 3D, very special session. Only country has is India. Only country has is India. And one more thing is, if you are doing some, what can I say, that is software related patents. Software related patents in the sense section 3K takes care of software related patents. As per Indian Patent Act, pure software programs are not patentable. As per Indian Patent Act, pure software programs are not patentable. Software coupled with hardware is patentable. Please take care. Software coupled with hardware is patentable. Pure software programs are not patentable. Then you may ask the question, why Infosys, HCL and CTS, TCS, these people are having a separate patent cell? As per Indian Patent Act, software programs not patentable, but American Patent Act, even the software programs are not. Software programs are patentable. So as an Indian citizen, he needs to file a patent in USA. He needs to get a permission from Indian Patent Office. So the software companies, they come to Indian Patent Office as per, they come to Indian Patent Office. They ask for a permission. So within 14 days time, we give a permission. So using this permission letter, they approach American Patent Office. They can file a patent. Okay. This is about the speciality of section 3K. Recently, some modifications have comes in 2016 and in 2018 for computer related inventions, in the sense how the software coupled, in which way it is software coupled with hardware, means in what sense. Pure algorithms, it's not patentable, but you can get a patent for algorithm, but how it is coupled with the hardware, that is the explanations, very good explanations given in section 3K, the CRF guidelines, CRI guidelines, computer related inventions. And recently the many problems are happening in what can I say, that gene technology, genes. So whatever the disease happens, the genes are responsible, not the medicines you are taking. Or for some people, for example, they say that if you smoke, there is 100% chance of getting cancer. Some people, they don't smoke, but they are getting cancer. Some people, they are continuously smoking, they are not getting cancer, but getting the chances of getting cancer for the smoking is more. But some ask the question, why some people are continuously smoking, they are not getting cancer, they never touch the cigarette, getting cancer? The answer is simple, because of your gene. Recently, one famous story has happened. That is a company called, in America, one company, the name is Myriad. The company name is Myriad. This company, they got a patent for BRCA1 and BRCA2 gene. BRCA1 and BRCA2 gene. The presence of BRCA, the method of identifying BRCA1 and BRCA2 gene in your body. What is the use of this invention? If suppose you have BRCA1 and BRCA2 gene in your body, 100% chance of getting breast. That is invention. That is the invention. They got a patent for this particular invention. Okay, they got a patent for this particular invention. So that one is not very beautiful invention the people thought, but it becomes a very famous invention once Angelina Jolie, she opted for that particular test. When Angelina Jolie, she opted for this particular test, unfortunately the doctors given report that Angelina Jolie has BRCA1 and BRCA2 gene and 100% chance of getting a breast cancer. Then immediately she opted for double mastectomy. Then she wrote the experience about her, what happens actually, how she struggled, how this particular invention saved her life. Saved her life. Okay. Then immediately what happened, after read her book, many US ladies, they stood in the queue, they opt for the particular test. They opt for the particular test. So the cost for doing the test is $4,000 US. in America, that everything is covered under that insurance policy, but testing procedure is not covered. Then immediately what Obama did, Obama Care Act he introduced. As per Obama Care Act, he included this testing procedure also. So that is the important of getting a gene patenting. So section 3I, which talks about, these are all the some of the special sections. So gene relates with the Myriad company, they made crores out of because of these inventions. So much of course they earned. So this is the main thing, some special features about Indian inventions. And in the sense, you may talk about the anyway of cup, that also one of the important things. And one more thing, I think you heard about the one inventor called, his name is the Margaret Knight. It is, don't think that invention means only the Einstein can do and other people can do. Okay, Margaret Knight, the female inventor in 19th century, there is a paper bag which has a flat bottom. Paper bag which has a flat bottom. Do you think it's a many great features? It's a very, very ordinary thing, but the Charles Hand, he stole her invention and patented himself. Finally, the knight sued in the courts and finally won. Finally won in the court. So very ordinary things is also patentable. Don't think that invention means only the Einstein can, only Newton can. Very ordinary things is also patentable. I think I have more things. I think almost it reached 11. It's a time to conclude my session. Thank you very much for your patient listening. If any people have some queries, you are welcome. I think I covered the general aspects about patent system or not, I don't know. If the people, tomorrow also I have one session. If you have any special questions, please ask.
Sir, participants can now put forth the question. Parthiban, sir, you have asked one question also. Now you can unmute your mic and go with the question. Hello.
Yes, sir. You are welcome, sir.
Raja Parthiban, sir, are you there? Sir, Vinay Shashwa. Vinaya, sir. So what is the acceptance percentage of software projects of UG students applying for patents?
What is the accepted percentage of software applications?
Yes, sir.
Indian applicants or foreign applicants?
Indian applicants, yes, asked, sir.
Okay, okay. So the software, you please, in today's scenario, as per this, the previously software related patents, people as such filing the software programs. The software programs are not patentable. The software related to hardware is definitely it is patentable. The recently the CRA guidelines 2016 and modified version also introduced. As per this modified thing, it is very easy to get a patent in software related patents. So now the 50% mark is improved to 80%. Only the 20% people are not getting software related patents. The reason behind is they are not giving reply within 6 months time. Once we issue FER, you need to give a reply within 6 month time. Many people, they are not giving reply. And once we give a hearing, the people are not attending the hearing. So this is a procedural reasons, and few patents were rejected based on the technical features. Okay. Now, as per the recent CRA guidelines, it is very easy. It is all the complicated things were minimized. Yeah.
So another one from Mr. Raja Parthiban, sir. How
Yeah,
will guide the students to file their innovation? What are all the steps, forms to be submitted, procedures for publication, and how much they will
charge?
Charge.
So this is very simple. So there is a misconception is there. the many people think that software, I mean, the patent means it is very costly. It's not the costly process. For getting a patent, there are 4 forms are required. The form 1, if you are an individual inventor, the hard copy for filing a form 1 is 1,750 rupees. The first thing. And second one is form 18, it is 4,400 rupees. And third thing, form 9, which is very much optional, 2,750 rupees. Once you file form 9, within a month time, that will be published in Government of India Gazette. Else it takes 18 months time to publish. The total cost is around 8,900 rupees for hard copy. If you file through soft copy, the 10% less.
Hello? Hello?
Yeah, please.
Someone has to mute the mic, ma. Someone has to mute the thing.
It is just
No.
8,900 rupees, nothing more than that. The people think that it is a very costly process. Why it becomes a costly process? The reason behind is the people so the cost for getting a patent is 8,900 rupees. If you come through the patent attorneys, they may charge about 50,000, means that cost will not come to Government of India account. The Government of India account in 8,900 rupees, you can definitely get a patent. Thank you. Next.
Lalu म्हणून एक जण आहेत, but he's a professor or associate, I don't.
Sorry?
Only.
Hello? Hello?
Yeah, please. Any other questions?
Yes, sir.
Wagman sir कसं आहे sir? आता about 55
Sir, we are working on a food
He's,
processing machine, slight
त्याच्याला पण दीड
variation
वर्ष
in
try.
design for other
Okay.
output. Can it be patentable?
प्रॉब्लेम झालेले आहेत.
Yes. It is patentable. Food processing machine.
त्यांनी थोडंसं
So
काम
you
केलं
can
असतं ना.
the claims. There is 2 things are there.
ती परिस्थिती त्यांच्यावर आली नसती.
Method claim also you can go for it.
पण त्यांनी तो विरोधच करायला
Operating
सुरुवात
this
केला.
food processing is one thing,
काही
and the
करून
second
विरोध
one
केला
is
तर काही फरक नाही
what are all the parts involved in that. So how the parts are coupled
पडत.
to
आणि
each other.
काहीतरी
What is a
बोलायचं.
characterized portion
माझे
of
सगळेच
the
मित्र
food processing machine? There are so many food
2 वर्ष
processing
संपादित,
machines
3
are
वर्ष
there,
संपादित.
but you might be having
संपादित.
some special feature in the food processing machine.
म्हणून ते वाटतं
You
मध्यंतरी,
concentrate on
दादा
this
साहेबांना
particular
खाली.
portion, you characterize this particular portion,
काहीतरी केलं
that
असेल
is
ना
your
त्यासाठी.
primary product claim.
Efficiency
Then
based
you can
जे
apply.
आहे, about
Then
55.
one more claim you make, that is a method claim. The first claim is parent claim,
त्याचा
then
activity
dependent
म्हणजे
claim,
नसेल तर मग तो
then you
problem
go
आहे.
for
ठीक आहे, आता
method
त्यांचा
claim.
जो आहे तो medical problem
Definitely
आहे.
it will be patentable.
त्याच्यावरती 1-2 वर्ष.
Hello, sir. Can we get any help for applying this patent? Hello,
Yeah,
sir.
yeah,
Myself,
definitely,
I'm Srinivas. So
Yeah,
I am designing
definitely,
this food
definitely. We
process
have a website
unit,
and you can
especially for
very well
millets, this
approach the patent
nutritional
office. We are ready to help.
cereals which are not
Promotion
having
list
the
त्यानंतर
Sir, I am
group
Dr. Manigandan from
actually
Erode.
that existing
Hello,
technologies are
ma'am,
for
can
wheat
you
and
Too
maida
many people
based.
are speaking. I
Can we
could not
get
hear
any
your
help?
voice.
We
Yeah,
have
I'll
we
mute
have
all.
changed
I'll
the
mute
method
all.
also as well as the
Please mute
design as
all
well.
and ask them. Yeah.
Hello, am I audible, sir?
Hello.
Yeah, you are audible. You please.
Sir, I have applied my research work in Indian patent 2 years back,
Okay.
and I have received a first information report 2 months before. In that they have mentioned that your patent is already applied in US patent. I mean, the implementation work was done in US itself, and that was patented in US, like that they have mentioned. But actually, my work is totally different from US patent. I have gone through it.
Okay.
Only thing is that the implementation part we have used the same thing, but the
Sir,
technique
this is a
used in
standard. Sir, don't worry. This is a standard procedure. When you
Okay.
apply a patent, immediately in the first
Okay.
examination report, something which is related to your invention, in
Yes.
the meaning of doubt, we raise these objections. Then within
Okay.
6 months time limit is there. You please give a reply. In the reply,
Okay,
you
sir,
say
okay.
that my invention is totally different from the US invention. In which are all the
Okay.
features? So I have a special characterized features. You give a reply.
அதுக்கப்புறம் என்ன மேம்
Okay.
சொல்லணும்?
It doesn't
Because
mean
I
that
have
your
used
patent is
Half an
refused.
hour.
You have allowed to give a
Okay,
reply within 6 months time. You give a
Thank you
reply,
சொல்லணும்ல நீங்க
so
அவருக்கு.
people will give a hearing chance also. Okay. just like that,
Okay, okay,
Indian
sir.
Patent Office will not refuse, but don't do the procedural mistake. You give a reply, right?
Okay, means okay, sir. They have given time up to until August to end. So within
Yeah,
that,
yeah.
I have
Within
to
August
certify
end,
all
you
these
please
things.
give a reply.
Okay, okay. Thank you, sir. Thank you.
Okay.
Hello, sir.
Yeah, please.
Sir, in our application, we have mentioned it as India and we have sent it for application, sir, but it was entered as Canada and it is still in the same scenario. We mailed it for the patent office of like this thing. So what is the thing we need to do it for that, sir? But in our
Sorry,
side,
sorry. Come again. I didn't get your question.
Yeah, sir. In our application, what we have done is we have filed it with applicant name and country as India. But
Okay.
what happened is in first publication, what it came as Canada for one applicant alone. That how it happened, we don't know, and we have again sent the proof to IPC help desk, such that we have mentioned India only, but it has entered as Canada like that. But we could not get any reply backs from
Yeah,
our Indian.
that's a
So,
good question. You are only one applicant or two applicants? How many applicants?
sir, 5 applicants.
5 applicants. If suppose one applicant is a foreign country applicant, okay. If suppose all the applicants are India, it's not a problem. If
No,
it
sir.
is a,
Sir,
one,
not everyone are India only, sir, but it has mistakenly entered as Canada.
oh,
Not from our side. Not
mistakenly
from our
you
side.
entered or office entered.
Office entered, not from our side, but from office it has been entered like that. Because in
Okay.
inventor,
So it is a office technical fault only. So in
yes,
your application, it is mentioned as that a scanned copy, form
yeah,
1, the scanned copy might be uploaded in our website. So in the
okay,
scanned copy, if it is India means definitely you contact our Rex session. Rex, the section called Rex. Okay.
Rex. Okay, sir.
The Rex, Mr. Manoj, he is in charge for the particular section. You
Okay,
please
sir.
call him and says
Okay.
that in form 1, all the
Okay.
inventors are India is scanned copy is there, but it is
Okay, sir.
mistakenly entered as
Okay.
Canada means immediately he will
Okay.
change. Otherwise,
Okay.
if you have any problem, you please
Okay, sir.
mail me and tell your application number. I will talk
Okay.
to the person and get it cleared. Okay,
Thank
no
you.
worries.
Thank you so much, sir. Thank you so much, sir. Yes, sir.
Yeah, Yadav sir, Rajnish Yadav, are you there, sir?
Yes, ma'am. Good morning.
Yeah, good morning. Yeah, you can
Good
go
morning,
with
ma'am.
it.
Good morning, sir. Thank you very much for delivering such a wonderful session. It was very wonderful, informative session. Sir, my question is, sir, what is difference in published patent and granted patent, basically?
Yeah. But the many people think that once whatever the patent, if your documents you are filing with Form 9, within a 1 month time, your abstract will be published in Government of India Gazette. Okay, that is called publication. It doesn't mean that it is granted. So why we are doing the publication means many people might be involved in the same field. So those people, we are giving a chance for them to object. That is called before the grant, they can go for pre-grant objection. After the grant also, you can go for objection. That is called post-grant objection. Within 1 year time, they need to do. Before the grant, that is pre-grant objection period. The publication with the Form 9, within 1 month time, it will happen. That is not a grant. So after publication, the controller will issue a first explanation report. You need to give a reply within 6 months time. After that, the controller will give a hearing. After that, he will give a grant certificate. That is a grant certificate. Many people misunderstood that publication and grant. Publication is anybody can get a publication, but not everyone will get a grant. Okay.
Thank you very much, sir. You have nicely explained. Thank you.
Thank you.
Thank you, sir. I think no more questions. Thank you, sir. Thank you very much, sir, for the answer.
Thank you. Thanks a lot.
Thank you, sir. Yeah, 1 minute, sir. 1 minute, sir.
Yeah.
Someone has raised hand. You can go with the.
Excuse me, sir.
Yeah, please.
Sir, in your lecture, you said that your own publication can become your enemy for the patent, sir. So
Yes.
it's like when I am publishing a paper and if I am using that work in my patent, it will become a problem. That is what you meant, right, sir?
Yes, right.
Okay.
So what actually it means is many people, many professors, they don't worry about patent. They are very much concentrating on the publications like IEEE publications or journal publications. So once they come to the patent office, your own publication will become your enemy. People rise your own publication as an objection, but within 1 year time, as per section 29, within 1 year time, if you come to patent office, we don't object. If your journal publication is more than a year, then your own invention will become your enemy.
Okay.
Sir, thank you, sir.
Thank you. Last one question.
Yeah, okay. Go on.
Lastly, one question.
Yeah, please, sir. Go ahead. Yeah, please.
Yes, sir. Thank you, sir. Sir, and he within 3 months he got first examination report, sir. In that it was asked what is what like that explanations. In our thing, we have gone for within 1 month the publication was happened. When the first examination report will come, sir? Whether we need to apply for the examination or it will come after? Or
no need. It is automatic process. So once you are file a patent, the form 1 is there, form 9, form 18, form 2. These are all the 4 documents required. Using form 9 within a month time, that will be published. So form 18 also you might have filed. So because of form 18, it is an automatic process. So in 6 months time, you will receive a first examination report.
Okay, sir. Okay, sir. Thank you, sir. Thank you so much, sir.
Thank you.
Excuse me, sir. Hello.
Yeah, please.
Sir, myself, Dr. Rakesh Kumar from Ravindranath Tagore University, Raisin. My question was that I have applied for design patent.
Okay.
And that is the because that was the first patent. I have put the diagram by hand. So the patent office asked me diagram in the 3D design. So now the 1 month is over. That is but due to some reason, I am unable to send these by post. Sir, is there any provision that I will send it now?
Yeah. You have a provision. Even for design application, it is very simple. There is no technical matters involved. Only the 6 views are required. If you take the 6 photographs and if you apply, means immediately application to Calcutta. So that if it is time limit is over, because due to the Corona period, we removed that time limit. Recently, we removed the time limit. You please quote the reason. Due to Corona reason, I couldn't apply within that particular time limit. So kindly accept means people are ready to accept.
Sir, we have only to send by post. We can mail also.
No, send by post. Indian post.
Okay, sir. Thank you, sir. Thanks a lot.
Thank you.
So one question from Venu Madhav, sir.
Yeah,
whether design patent can be treated equivalent to full patent? What is the actual difference between design and a patent?
Yeah, design means it is there is no technical features involved. Only that, for example, if suppose the table is there, for a table, the method of making the table, how it is assembled, what is the technical features involved, how the drawers and the threads are arranged, what is a screw arrangement. In the technical matters, if you are disclosing, means that becomes patent. Only the 6 photographs, top view, front view, side view, aesthetic appearance. This aesthetic appearance is related to designs. Design within 6 months time you will get. Okay. Only the aesthetic appearance is designs. Technical features is patent. So design is not equal to patent. The many people think that patent and designs are the same. The patent is different. Design is different.
Thank you, sir. Thank you very much for the wonderful session, sir. I think we'll be meeting it again. Thank you, sir. Thank you very much.
Thanks a lot. Can I leave now?
Yes, sir. Yes, sir. Dear participants, we can meet after a short break. By 11:40, kindly join the session. Okay. 11:45 sharply we'll start the session.
Thank you.
Okay. Thank you. Thank you.